Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy, Chapter 7 and Chapter 13. Joining me as always, my co-host, Jesse Barrientes. Jesse, how are you today?
I'm doing great, Dave. How about yourself?
I'm doing pretty good.
Excellent. Happy fall.
Happy fall is right. Chapter 7.
Chapter 7. Well, hey, before we talk about Chapter 7, I know in one of our previous shows here, we talked about the state courts, the new filing throughout Illinois. So everything pretty much has to be electronically filed. There's an exemption that they allow in the state courts for people who don't have a computer for whatever reason are not able to do that. Right. So, but we're talking state court. All right, let's talk federal.
Attorneys in federal court have to file electronically. If not, they're going to be brought before the court to explain why they didn't file it electronically, and they could be held in contempt.
Well, if it's not an attorney, what about
a pro se litigant?
Yeah,
they can file whatever they want through the clerk, face to face, at 219 South Dearborn.
And the clerk will just stamp it for them.
The clerk will file anything that's prepared. They have to. They're mandated. They have to accept it. They have to file it. So even if a letter comes from a pro se complaining about something in the system, it gets stamped, it gets filed. But attorneys don't have that luxury. They have to do it electronically, which is actually working out pretty good for the attorneys in bankruptcy court.
Okay, so bankruptcy court, so that they have to do that.
The system's been set up long before the state court electronic filing. You scan in a PDF. Yeah. It just works real well. It's automatic.
Actually, I remember that because that's when I got my first full-blown Adobe suite there. That was for that reason, for federal filings. So, all right, so now we're talking a little bit about that process, how it differs a little bit. So it's not as stringent for the pro se filer.
Right.
But for anybody else, I got to do that. So, Chapter 7.
Well, that's the fresh start, Jesse. That's when someone who doesn't have a lot in the way of assets, but has a lot of debt, wants to get a clean slate, or at least as clean a slate as they can. Some debts don't go away. And they file a Chapter 7 through an attorney or on their own if they feel so daring.
Let's back up now. We talked about in our last show against state court about well, not just divorce, but all of the forms that are provided for people by the state of Illinois that are standardized forms for people to file on their own. Okay. Mm-hmm. Still got to know what you're doing and everything else. There's still deadlines and all that stuff. So with respect to bank, and I don't know how long it's been now, 10, 15 years since they really changed the law with respect to adding things for the bankruptcy.
2005 is when the major law changed. So we're at 14 years now.
Okay, so it's 14 years. Okay. So
this coming October 17th.
So there's a difficulty then, again, even for somebody to file on their own a Chapter 7.
It is. There are forms available online, federal forms and local forms. If somebody really wants to do it on their own, they could try it. They do run the risk, though, that they're going to be filing a case that has an asset that's going to be taken from them, or they're not going to protect or properly notify certain creditors. So there are some hang-ups to doing it yourself. So I don't recommend it, even for someone who doesn't have a lot but wants to get a fresh start.
Right.
It's hopefully the only time they're going to file a bankruptcy. There's attorneys out there that do it affordably with payment plans. There's no reason just to run to the courthouse and file on your own without, exploring the opportunities available through a professional.
Oh, and I'm going to ask you about some of those requirements here too. But as you were saying that, I was reflecting back in the day. I remember doing the Chapter 7 bankruptcy forms on a typryper, Dave.
That's right.
On a typewriter.
Right. The forms you purchase at
some of the people that are viewing
supply
probably don't know what a typewriter is because really do you see them anymore?
Right. Or a corded phone.
Or a corded phone. That's true. Yeah. So that just it gave me a little smile. I remember it was a long time ago. But so the Chapter 7. All right. So let's talk about, again, we're talking about procedure, and this could be a stumbling block. Before you actually file your petition, is there anything you got to do?
Yes. You have to complete a pre-filing credit counseling session. It's basically an hour or an hour and a half, either on the phone or online, with an approved company, approved by the United States Trustee's Office, to give you a briefing, a credit counseling briefing. This has to be done before a case is officially filed. There are a couple exceptions, but...
Well, what happens if, for example, okay, so I file my Chapter 7 bankruptcy case, and I take the class the same day?
Same day.
Right.
Did you complete the course before you filed?
No.
Then there's a chance that your filing will be void.
And then I'm going to lose out on my money, my filing fee.
You just lost your filing fee.
What does it cost to file?
$335.
So if that happens and I get knocked out because, I missed it by a minute, I'm going to have to pay another $335?
I think you've lost your money.
Wow. Okay. Because that's a jurisdictional requirement, correct?
That's right. A couple other important requirements. Not as important as the credit counseling,
Sure.
which has to be done.
Okay.
But you must have a couple months' worth of proof of income, pay advices, check stubs, Social Security statements, award letters, unemployment, workers' comp, and the most recent year under the code of your federal tax return.
Well, let's talk about that. Sometimes people, for whatever reason, don't file a tax return.
Don't file or didn't have to file?
Well,
Two different things.
right.
Didn't have to file.
Didn't have to file.
We can do a statement saying they weren't required to file,
and
that's
that's
okay.
no problem. What about, hey, I skipped a couple years, Dave.
Well, under the code, they just need to file their most recent year. Doesn't matter if they owe money.
No, so what happens if I didn't file this most recent year? Then what happens? I got to go back and...
You need to file it. Otherwise, your case will be dismissed 46 days after filing automatically by the court.
Okay, so I have to do
Without motion. Automatic dismissal within 46 days.
Are these records submitted to the bankruptcy court?
They're submitted to the trustee.
The trustee. And so the
Trustee
trustee...
is a person appointed, by the way, to oversee your case,
Okay.
to make sure you don't have any assets that could be administered, sold, and paid to your creditors.
Sure.
And the trustee also wants to verify that the information in your schedules is true and accurate.
So if he doesn't get that information from you, he's the one who checks the box or does something and it gets kicked in 46 days.
That is correct.
Okay.
So those are the pre-filing requirements.
So I have to then I have to file. So if I didn't file for taxes and I'm late, I have to file.
Yeah. By the way, every one of those requirements is new since 2005. Those were never required to be provided. There was never credit counseling. There was never a financial management class that you had to submit to for 2 hours.
Well, that's why I'm in the position I'm in, Dave, because I didn't have financial counseling.
Well, I got news for you. It's not going to make that much of a difference if you don't correct some of the financial habits that you have lived with for the last 50 years.
So these are just additional hoops to jump through to get the bankruptcy that you want.
Yeah. I think the hope was the legislature thought that if someone did a credit counseling session before filing, that maybe they would decide not to file and they would work into a debt repayment plan with their creditors. But to be honest with you, the bankruptcy attorneys are referring these people to the credit counseling so that they can file. So it's not making any difference in terms of that. There's been some talk about maybe someday removing these requirements because they're not really having the effect that the legislature thought. But as of right now, they still exist. They must be complied with. And I tell my clients, you just have to do it, comply, and you'll get a fresh start.
So what happens, if you're up at 3 or so in the morning, Dave, you'll see a lot of these commercials, infomercials, maybe not info, but just a regular commercial, telling me that, hey, I can get rid of my debt without filing bankruptcy as long as I have $10,000 in debt or more.
Yeah, those are...
And I don't have to pay until the end.
Well, what they're trying to do is they're trying to hone in on people who are struggling financially but are averse to filing a bankruptcy. So they're looking for any reason not to file a bankruptcy because of a stigma or how it makes them feel. But in reality, the debt consolidation companies don't have much strength. So some creditors might agree to take less. Some might decide to not participate at all, and they can go ahead and sue you, garnish your wages, seize your bank account, repo your auto. So I do not recommend debt consolidation for anyone if you compare it to the relief that you get from a Chapter 7 bankruptcy.
Chapter 7 is federal.
It's federal. It's got strength. Creditors have to abide by the bankruptcy protection. Immediately when a case is filed, there's something called an automatic stay, which is a big stop sign that goes out to all the creditors and says, hey, this person's filed. You cannot take certain actions to collect.
Oh, until this is done and see where we're at here.
Or with court approval.
With court approval. Okay. So you file the bankruptcy. So I have all this stuff. Then I come into. So what happens in terms of taxes? What happens if I got an extension?
Extension on your taxes?
Yeah.
Well, That's a great question. In a Chapter 13 scenario, which is where you're repaying back your debt, the trustees are not accepting of an extension because the code, the way it's written, says you must have filed your most recent federal tax return.
But the law also allows me to file an extension, which then my income tax returns has to be filed in
Yes.
October for a lot of reasons. One of those reasons, perhaps, is funding a retirement or any other number of reasons.
It's a contested issue in a Chapter 13.
What about a Chapter 7?
Chapter 7, for the most part, if you have your extension and you have the year before that federal return, for the most part, those trustees are going to be more accepting. But there's another reason, too. They want to complete the case. They want to move on. If there's not an asset, they don't want to invest any more time. They want to make their certain fee per case and move on. So,
Okay. So we have that. So now we do everything. You filed the case. So what can I expect?
well, 4 to 6 weeks after the case is filed, you are going to appear before a Chapter 7 trustee.
That's the trustee you're talking about earlier.
Yes,
that was
that's the
appointed.
person assigned to your case to make sure that you don't have any assets that can be taken and that the information in the schedule is true and accurate. Trustee is going to swear you in, ask you a series of yes/no questions. The meeting takes about 5 to 10 minutes tops. Sometimes there's amendments that need to be made after the fact, but for the most part, a Chapter 7 case, if it's done properly by an experienced attorney, you're going to have a good result, and you're not going to have to do anything after that meeting except wait 2 months for your final letter in the mail that says it's over, discharge of debt.
I know some of those trustees still have the little cassette tapes that they record you.
Yes, they are all recorded. Yeah, everything's recorded, everything's under oath. They keep those tapes. They want to make sure that first of all, that the trustee is administering the case properly.
Put a cassette tape, Dave.
Oh, cassette tape?
Yeah, I've seen it. So anyway,
iPhones, cassette tapes.
well, so that's done. So now let's talk about what I can do here, or what am I going to be protected on? So, I got a
Depends
lot
on your
of debt. So credit card debt, consumer debt.
Most credit card debt is going to be eliminated in a Chapter 7. Not a problem.
How about my house?
Depends.
I want to keep my house. There's not a problem with that. In fact, the reason why I have all this other debt is because I've been robbing Peter to pay Paul to make sure that I maintain my mortgage.
Illinois law allows you to keep a certain amount of property, whether it be real estate, a vehicle, your 401k, $4,000 miscellaneous property. You can protect this property while going through the process of eliminating your debt. So with regard to your house,
Yes.
as long as there's not significant equity, okay, it's $15,000 per person. So if it's husband and wife, $30,000.
So even
It's
if
a lot of equity.
even if only one person is filing, you still get the 30 because that's that person's amount.
I would argue you get the 15 plus the non-filing spouse gets 50% of their equity,
Of
so
the
even
half.
more so.
So even more for that. Okay.
Yeah, so if there's not significant equity, you're going to be able to keep your house, provided you continue to make your payment. Same thing with a car.
Okay, yeah, so that's the thing with the car. I know, I've been told that after bankruptcy, I'm not going to be able to, to do much here. So,
It's a misnomer, actually.
Well, we'll talk about that. But the thought is that, okay, listen, I need to keep this car because I need a car to get to work. If I don't have a car to get to work, then bankruptcy is not going to help me because I'm just going to be right back where I am.
Well, that's true, but let's say the car you have is way upside down. It's worth 10 and you owe 20 or 25, I've seen. That's not a good situation for you.
Well,
So
how am I going to get another car? I've done a bankruptcy. No one's going to touch me.
the minute you get a case number, you'll be able to get a car at a number of dealerships. In fact, clients get 10 to 20 letters after filing wanting them to come in and get a car. And the reason why this happens is, one, it's going to be a higher interest rate, but you're probably going to be at an even equity situation, so you might be better off even with a higher rate. And the lender knows you can't file again for 8 years.
8 years in a day, right?
Yeah, so if you don't make a payment, they're going to repo the car, they're going to pursue a deficiency. So it's a win-win for both.
Right.
You're able to get into a new car or a used car at a decent rate, and the lender knows there's not high risk because if you can't pay, they're going to get the car back and have an opportunity to collect.
But what if I want to keep this car because I'm not upside down?
Well, that's called reaffirming a debt. You could do that, but you're going to do that with the advice of your attorney.
Okay.
You're going to make the ultimate decision whether you want to do it or not, and then do you have the means to do it? Do you have the ability, after you get out of debt, income minus expenses, can you show the court that you can make that payment? If you can't show the court that you can make the payment, the judge may not approve an agreement, and then you're on kind of the mercy of the lender to continue to accept payments. And most will do that except
Or
for a
not,
couple.
right, exactly for that. Okay, so you mentioned too in terms about getting the car. So what happens, I've had people come in and ask me, oh, well, hey, listen, I don't have anything on this card or a very nominal amount. I don't want to include this card.
Can't pick and choose, unfortunately. Any kind of debt
But
that you
Dave,
have
listen,
has to be listed.
I've had this Discover card since I was, 18.
Who cares?
Right.
Why do people care about that?
I don't
mean, I
know.
do hear that too.
Yeah.
It's my first card. Well, guess what? That's what started the whole chain of
Yeah,
bad
it sure
stuff.
did, didn't it?
And you know what, Jesse? You'll be able to get credit again. It takes about 6 months to a year. You can get a secured card anytime after filing, put money in the bank, you can charge. It eventually turns into an unsecured card. Your credit score will go up tremendously after about 6 months to a year and a half. People are amazed at how fast they rebound. They get offers for credit. They're able to save money. They protected their 401k.
Oh, yeah, so I was going to talk to you about that too. So, yeah, what about my retirement then? Is that...
It's 100% protected. So it would be foolish for you to dilute it as you're trying to prevent yourself from filing. In other words, robbing
That's what a
from
lot of
your
people
retirement.
do, though. Oh, they
do.
What they do is they rate it,
Because they don't know.
and
that
then it's
protected.
gone, and then they're still back in the place they were when they rated it.
Right. Because, again, they don't want to file. They're doing everything they can to prevent from filing. They think they have a little savings there that they could apply towards the
Sure.
credit. It's not a good idea. That's your retirement income.
Well, what about, Dave, I got hurt at work, and I have a workers' comp claim. So are they going to take that money from me?
No, workers' comp is 100% protected. One exception. If you have a third-party claim against some kind of machinery, let's say you're hurt at work by a forklift that malfunctioned.
And so my attorneys, in addition to getting workers' comp, they go after the forklift builder
Right.
or
And that's a
manufacturer.
personal injury case. We call it a third-party claim.
Right.
That comes into the injury exemption. So that's $15,000 you could protect there.
So that's true with, let's take my example. Let's say it was just a car accident case. I could,
$15,000 protected.
and that's it.
The first $15,000 that goes in your pocket, protected. Anything over that, the trustee could take to pay your creditors. And that's fair.
Well, what happens? Does the trustee then get an attorney to pursue the claim, or does the attorney that you've already hired allow to complete it?
Most cases, the trustee will stand off to the side while your current attorney prosecutes the case. Of course, that attorney has to report to the trustee with regard to the settlement. But yeah, the trustee's not interested necessarily in hiring their own attorney. They just want to wait
Liquidate
for an
it.
asset that may
Sure.
or may not come. You might get a not liable
Okay. So
after a jury trial.
that's absolutely true, and then that's into that.
Trustee doesn't want to invest in that.
There is also, and I don't remember exactly, you probably remember this, a rule. And that is that if I didn't report it
Yeah, very true.
on my bankruptcy, and then I sue this other person,
Yeah,
they can use that in that civil litigation to get the case dismissed.
that's a good point. They can try and do that. Worse than that, you might have lost your lawsuit to the bankruptcy trustee. The case is Yannikis. You have a duty to disclose the existence of your lawsuit. Even workers' comp, that would have been 100% protected if you just told your attorney about it and properly listed it. The trustee in your case might exclude you from your own lawsuit and take all of the proceeds
And
because
so
you
I
were
won't-
not an honest debtor.
I won't get anything then.
You might not, and that's the Yannikis case, which is a very important case
Right.
in this jurisdiction. Basically, Jesse,
You got to
disclose
tell the
everything.
truth, right? You got to tell
Everything.
the truth because also I think there's even something worse than that.
Oh,
Okay?
yeah.
That's fraud and
Bankruptcy
perjury.
crimes.
Right. So now you're going from being broke to being incarcerated and broke.
Yeah, very true.
Because you're lying on something that you're under
Yeah,
oath. It's perjury.
It depends on the gravity of it. Thankfully, I haven't had a case where someone purposely failed to disclose either an interest in property such as land or a building or huge bank accounts with
Right.
stockpiles of money. That would be a bankruptcy crime, and the trustee or the U.S. Trustee's office could refer that to the state's attorney or the attorney general, and that could be a problem. But luckily, when clients are advised of this fact, and once their right hand is up and they're giving sworn testimony, they often will come forward with anything that they might not have been forthcoming with before.
There's been a time or two in a divorce case where I've had someone on the other side, oh, they forgot a pension.
Yeah.
Yeah, right. That's certainly a different circumstance. But
Right.
anyway, so
And they have to be careful too, because people that they might owe money to, say family or friends
Sure.
or acquaintances, those people might know of an asset or might know of something that wasn't disclosed in the paperwork.
and hey,
Remember,
listen,
they
this,
didn't get their money.
this
so
guy
they're
is
mad.
gonna right. He's just so
So
right.
they'll whisper in the trustee's ear, hey, ask him about what happened to that piece of property in Wisconsin on the lake
Right.
that he bragged was paid for and was worth $800,000. What happened
Where's
to
what
that?
happened to that? So
Right.
disclosure is very, very important. So we talked about the retirement being protected. We talked about the exemption for the house and all that. So
And the vehicle.
And the vehicle. And we talked about being able to get a car and to get credit after the filing, and how then your score goes up and everything. So let's talk about a couple things, because you had mentioned earlier there are certain things that can't be discharged. So look, hey, you know what? We just in our last show we talked about child support and maintenance, and so you know what, Dave? I was a little behind for a couple of years here, and I owe my ex a ton of money. So hey, this is going to be great. I can't wait.
Yeah.
I can't wait to bankrupt that out, and then I can't wait to see the look on her face.
Yeah, you're going to continue to owe that maintenance.
Oh, what do you mean?
Continue to owe that child support. Those are non-dischargeable debts, as are student loans.
Okay, wait a second. Now, hang on. Listen, you know, I might have gone through a toll or two without my transponder.
You got to pay it. Technically, it's non-dischargeable. So is a moving violation. So is a parking ticket in most counties. So are student loans.
How about taxes?
Recent taxes, non-dischargeable. If it's more than 3 years old, you have a chance that it could be discharged.
But not guaranteed.
Not guaranteed.
You know, it's funny. I remember I had actually a couple people that had come in that had the toll violations of, one was 30 and one was like $45,000.
How is that possible?
The fee, they keep on going through it, and they also add penalties and interest, and it keeps on going up. And this isn't one of these cases where you have your ex's car, okay, because you get that sometimes. That's what happens, and you know, because it's hooked up to the license plate, not necessarily who's driving it.
I have an option for you on that.
And so my question is exactly, it's like, are you serious?
Well, it's not eliminated in a 7,
Right,
but you
but-
might be able to pay it a percentage in a Chapter 13 over 3 to 5 years, as little as 10% typically. Not a bad deal.
And then after that's over, you won't have to pay the difference.
Correct. It's wiped out.
Okay,
Discharged.
Let's talk about that in a minute. So that's if we have time there. So all right, so we've talked about these things in the Chapter 7, so things that aren't dischargeable. Well, let me ask you this. Is there an amount of money that's too much for me to owe to do a Chapter 7?
No. No. Chapter 7 has no limitations.
So I can owe $10 million?
No debt limits. Chapter 13 has debt limits, but yeah.
Well-
Chapter 7, you know, we've done cases where, unfortunately, people have perished as a result of traffic accidents, truckers and things like that, and it doesn't matter what the dollar amount is, the debt's discharged.
Okay, and that's the end of that then.
Yeah.
So
it's a
what
fresh
about,
start. It's an amazing benefit, Jesse.
can I make can I make too much money to do a Chapter 7?
Yes, you definitely can make too much money. Remember, Chapter 7 is
You
for
just-
someone who doesn't have significant assets,
Okay.
doesn't have the ability to repay the debt, so their income and expenses don't show a surplus.
Right?
They're making under the median for a family of their size based on IRS guidelines. I think in Illinois, single person, it's about $52,000. For a family of 3, it goes up to about $68,000. So you can make significant money and still qualify for Chapter 7 if you don't have a surplus above and beyond your expenses each month.
Okay, and is that what they call the means test?
Yes, it's called the means test, but basically it's saying, does this person have the means to repay? And if they don't have the means to repay, then they're able to avail themselves of the Chapter 7 bankruptcy laws and get that fresh start that they so richly need.
So, well, what happens if it's just me filing? So
Just you
I
filing?
don't, yeah, I don't have to include my wife's income.
Not true.
What?
Your wife's income is a factor because it's the total household income. Exception would be if you're separated and not legally separated. Let's say you're living separate and apart. It's not working out. Her income would not be a factor there. But
What
if
if,
you're living
what if
together,
she's living in the attic? Or
that's
I'm living in the
together.
attic.
That's together. That's one household.
Okay.
The theory there is that the marital property should be used, the non-filing spouse's income should be factored in to help the filing spouse.
Okay. So we've talked a little about that. I know we don't have a whole lot of time, so I just really want to ask the difference then between, so Chapter 7, fresh start. Chapter 13, consolidation or partial repayment. Tell me a little bit about
Chapter
that.
13 is someone is behind on their mortgage, they're behind on their car, they have otherwise non-dischargeable debt, student loans, recent taxes, parking tickets, child support, alimony, and they want to repay that or a portion of it over time, and they have the ability to pay it. So their income exceeds their expenses per month. Even by $200, $300, whatever that amount is, that's what's required to be paid, whatever your surplus is, into a Chapter 13 over a 3 to 5 year period. It's complicated. There's a number of factors based on your assets, your income, your liabilities.
And that would be absolutely even worse to try to do on my own.
100%. And there's people who try it all the time, and their cases get dismissed left and right because they just don't know how to navigate the system. They don't know how to prepare a proper repayment plan. This is where you need a seasoned bankruptcy attorney, not one that just came out of school and does a few Chapter 7s here and there. Chapter 13 is a total different animal. There's different requirements. Definitely do not go alone in a Chapter 13. It's my strongest recommendation today.
And but that again, here's another option again. Fresh start, and then look, kind of got behind, whether or not it's from medical bills or accident or divorce or whatever it is, but there is a light at the end of the tunnel that's not a train.
That's right. And the most common reasons for a Chapter 13, and these are important, to save a house that's in foreclosure.
Mm-hmm.
You might have fallen behind for an illness, injury, divorce. Now you're back working. You want to repay it so you can make your regular mortgage again, plus pay the part you fell behind. You can pay that back over 3 to 5 years.
And
that's a nice blessing.
And you mentioned, too, that you can, in a Chapter 13, that, hey, look, basically, you either pay any percent, you pay 100% of your secured creditors, and from 100% all the way down to 10% of your unsecured.
If your income dictates you can only pay that much.
Right.
If you're a breadwinner and you're making a ton of money.
If it changes, then you pay 100%.
You're going to pay 100% back.
But you could pay as little as 10%, as much as 100% over that time period.
That's right. We could also reduce the interest that's being paid. There's a number of factors there. The benefit, though, is you're saving your property. You're keeping all of your property. You're not losing anything when you're in the repayment plan.
And so when you're doing something like that, even if I have 2 mortgages, the second mortgage, if that overshadows the value of the property, what happens there?
Oh, you're talking about if the first mortgage exceeds the value?
Yes.
The whole second mortgage is basically unsecured, and it can be stripped away and paid as an unsecured creditor.
So it's 10%, just like you were talking about a little earlier.
That's a lien stripping deal. Very complicated. We'll get into that another time. Thanks, Jesse.
Very good, Dave.
Good to see you.
You too.
You've been watching Legal Action, talking bankruptcy, Chapter 7 and Chapter 13. We'll see you next time. Take care.